Hello Year 11s and welcome to this video on key concepts of civil law. There are 4 things that you need to do while you're watching this video. The first thing is to take the very best Cornell notes that you can. The second thing is to use the pause and rewind functions. Use the pause function if you need to stop this video to take notes. Use the rewind function if you need to go back over any information contained in this video. The third thing that you need to do is have your vocabulary sheets open in front of you so that you can write down in your vocabulary sheets the meanings of key terms and of any other words the meaning of which you're unfamiliar with. And the fourth thing that you need to do is have your summary books open in front of you. As we go through this video, I will give you some guidance as to what you should include in your summary books. Once you've finished watching this video, make sure that you read the pages from the textbook referred to on this slide. And if you find any additional information from that reading that you think is useful, supplement your Cornell notes with that additional information. Well, let's get started then. On this slide, I've set out your learning intention. Make sure that you write this learning intention down in your Cornell notes. As a result of watching and taking notes on this video, you should be able to explain key concepts of civil law, including plaintiff, defendant, the burden of proof, the standard of proof, breach, causation, loss, and limitation of actions. In this video, we'll be looking at the 8 key concepts of civil law that are referred to in the learning intention. I've listed these concepts in the left-hand side of this table. In the right-hand side of this table, I've suggested how you could describe each of these concepts, including by using definitions and examples. Please draw up a table like this in your summary books and complete the right-hand side of this table as you work through this video and in accordance with the suggestions that are in italics. The first key concept is the concept of a plaintiff. A plaintiff is a party who claims that another party has committed a civil wrong. Look down the left-hand side of your vocabulary sheets, find the term plaintiff and write this definition in there. You may recall Max from our previous video. Max was walking along one night when he fell into a hole in the footpath that had been dug by the Brimbank Council. Max is an example of a plaintiff because when he sues the Brimbank Council, he will be claiming that the Brimbank Council has committed the civil wrong of negligence against him. The second key concept that you need to understand is the concept of a defendant. A defendant is a party who is alleged to have committed a civil wrong. Look down the left-hand side of your vocabulary sheets, find the term defendant and write this definition in there. There are at least 3 different types of defendants, and it's possible that a plaintiff might be able to sue 2 or more of these different types of defendants in relation to the one civil wrong. The 3 types of defendants that you need to know are the wrongdoer, a person involved in the wrongdoing, and the wrongdoer's employer. A wrongdoer is a person who infringes the plaintiff's rights and causes the plaintiff to suffer loss. Look down the left-hand side of your vocabulary sheets, find the term wrongdoer and write this definition in there. In Max's case, the wrongdoer would be the Brimbank Council worker who actually dug the hole. The second type of defendant is a person who is involved in the wrongdoing. A person who is involved in the wrongdoing in the sense that they encourage or assist the wrongdoer to infringe the plaintiff's rights will have accessorial liability. That is, they will be liable to the plaintiff for encouraging or assisting the wrongdoer to infringe the plaintiff's rights. Look down the left-hand side of your vocabulary sheet, find the term accessorial liability and write this definition in there. Once you've done that, highlight the words in red, bold, italicized type. And, if you're ever required to define or describe the concept of accessorial liability, make sure that you include those highlighted words in your definition. Now, it's very important not to confuse the civil law concept of accessorial liability with the criminal law concept of accessory. An example of accessorial liability is where a passenger in a car encourages the driver to speed, and the driver crashes into a pedestrian who is crossing the road. In such a case, the pedestrian can sue the driver of the car as the wrongdoer, that is, as the person who has infringed the pedestrian's rights and injured the pedestrian. However, the pedestrian can also sue the passenger on the basis of the passenger's accessorial liability, that is, the liability that the passenger has to the pedestrian for encouraging the driver to drive negligently. The third type of defendant is the wrongdoer's employer. Where an employee infringes a plaintiff's rights while acting in the course of their employment, then their employer will have vicarious liability for the losses that are caused to the plaintiff. That is, the employer will be responsible to the plaintiff for the losses that are caused by the employee. Look down the left-hand side of your vocabulary sheets, find the term vicarious liability and write this definition in there. Once you've done that, highlight the words in red, bold, italicized type. And if you're ever required to define or describe the concept of vicarious liability, make sure that you include the highlighted words in your definition. An example of vicarious liability is where a newspaper reporter writes a defamatory article about another person. In such a case, the defamed person can sue the newspaper reporter as the wrongdoer, that is, as the person who has infringed the plaintiff's rights and who has caused injury to the plaintiff's reputation. However, the defamed person can also sue the newspaper company as the newspaper reporter's employer. This is because in writing the defamatory article, the newspaper reporter was acting in the course of their employment. The newspaper reporter's employment requires the newspaper reporter to write newspaper articles. Now note that for an employer to be vicariously liable for an employee, that employee must be acting in the course of their employment. So, for example, if the newspaper reporter had hurt another employee of the newspaper company by playing a prank on that other employee, then the newspaper reporter's employer, that is the newspaper company, would not be vicariously liable for that injury. This is because it is not part of a newspaper reporter's employment to play pranks on other employees. The third key concept that you need to understand is the burden of proof. The burden of proof, also known as the onus of proof, is the responsibility of a party to prove a case. Look down the left-hand side of your vocabulary sheets, find the term burden of proof and write this definition in there. In a civil case, it is the plaintiff who bears the burden of proof. That is, it is the plaintiff who must prove that the defendant committed the civil wrong. Put another way, in a civil case, the defendant does not have to prove that they did not commit the civil wrong. That's because it is the plaintiff, not the defendant, who has the burden of proof in a civil case.
However, you must not confuse this with the presumption of innocence in criminal cases. The presumption of innocence is a criminal concept, and you must never talk about the presumption of innocence where you are dealing with a civil case. Now, even though the plaintiff has the burden of proving that the defendant committed the civil wrong against the plaintiff, there are some circumstances in which the defendant is responsible for proving other facts that are relevant to the case. That is, there are some circumstances in which the defendant has the burden of proving these other facts.
The first circumstance is where the defendant brings a counterclaim, that is, where the defendant sues the plaintiff. Let's take the case of a plaintiff who agrees to sell the plaintiff's car to the defendant for $10,000, but the defendant only pays the plaintiff $6,000. In such a case, the plaintiff might sue the defendant for failing to pay the agreed price of $10,000. The plaintiff then has the burden of proving that the defendant has breached the contract between the plaintiff and the defendant by paying only $6,000 rather than $10,000 for the car. But let's now assume that the defendant thought that what the plaintiff was selling the defendant was a new car rather than a used car, and that the plaintiff's car is actually a used car. In such a case, the defendant might counterclaim against the plaintiff. That is, the defendant might sue the plaintiff for breaching the contract between them. The defendant would be arguing that the plaintiff has breached the contract between them by selling the defendant a used car rather than a new car. To establish the counterclaim, it is the defendant who bears the burden of proving that the plaintiff has breached the contract between them by selling the defendant a used car rather than a new car. The second circumstance where the defendant has a burden of proof is where the defendant raises a defence, for example, the defence of contributory negligence. So, for instance, the defendant might have been driving a car too fast along a road when the plaintiff steps out in front of the defendant's car without looking. In such a case, the plaintiff might sue the defendant for negligence, and because the burden of proving that the defendant was negligent is on the plaintiff, it is for the plaintiff to establish that the defendant was in fact negligent. However, the defendant could raise the defence of contributory negligence. That is, that the plaintiff is partly responsible for their loss by crossing the road without looking. If this defence is successful, then the amount of damages that the defendant is required to pay the plaintiff will be reduced, because part of the plaintiff's loss was caused by the plaintiff rather than by the defendant. However, for this defence to be successful, the defendant has the burden of proving that the plaintiff was in fact negligent, so that there is contributory negligence. Now, this is very different from the criminal law, which is where the accused raises a defence. It is not for the accused to prove the existence of that defence. Instead, it is the prosecution that has the burden of proving that the defence does not exist. The fourth key concept that you need to understand is the standard of proof. The standard of proof is the strength of evidence needed to prove a case. Look down the left-hand side of your vocabulary sheets, find the term standard of proof, and write this definition in there. In a civil case, the plaintiff must prove on the balance of probabilities that the defendant has committed the civil wrong. That is, the standard of proof in a civil case is on the balance of probabilities. What this means is that it must be more likely than not, that is, there must be more than a 50% chance that the defendant committed the civil wrong. This is a very different standard of proof from the standard of proof which applies in a criminal case. In a criminal case, you'll remember that the standard of proof is beyond reasonable doubt. That is, the prosecution must prove beyond reasonable doubt that the accused committed the crime. This means that the only reasonable explanation for what happened must be that the accused committed the crime. That's a much higher standard of proof than for the civil case, where all the plaintiff has to prove is that it is more likely than not that the defendant committed the civil wrong. If the plaintiff can't prove on the balance of probabilities that the defendant committed the civil wrong, then the plaintiff's claim is dismissed and the defendant is not liable for that civil wrong. This brings us to four concepts that are relevant to most kinds of civil law. These concepts are breach, causation, loss, and limitation of actions. Turning first of all to breach. You'll remember that a plaintiff is a party who claims that another party has committed a civil wrong, and a defendant is the party who is alleged to have committed that civil wrong. Civil wrongs include negligence, defamation, and breach of contract. The most common way in which a defendant commits a civil wrong is by breaching an obligation, an agreement, or a law. The word breach means fail to comply with. Look down the left-hand side of your vocabulary sheets, find the word breach, and write this definition in there. So, for example, in the law of negligence, the defendant breaches an obligation that they owe to the plaintiff to exercise reasonable care. In the law of contract, the defendant breaches an agreement that the defendant has with the plaintiff. And in equal opportunities law, the defendant breaches the law if they discriminate against the plaintiff. The main law in Victoria that prohibits one person discriminating against another person is the Victorian Equal Opportunity Act 2010. So, for example, a school would commit a civil wrong if the school breached the Equal Opportunity Law by refusing to allow a student to enrol in the school because the student is a member of the Sikh community and wears a turban. In that case, the school is breaching the Equal Opportunity Law by discriminating against the student because of the clothes that that student wears. The next important concept is the concept of causation. For a defendant to be liable to a plaintiff for a civil wrong, the plaintiff will generally need to prove causation. That is, that the defendant caused loss to the plaintiff. Causation means that the plaintiff suffered loss because of something the defendant did or omitted to do, that is, failed to do. Look down the left-hand side of your vocabulary sheets, find the term causation and write this definition in there. Let's take an example. Suppose that Reggie, the defendant, negligently injures Trung, the plaintiff, and that Trung loses his job. The question is, did Reggie injuring Trung cause Trung to lose his job? The answer to this question depends on whether Trung lost his job because of his injury, or whether Trung lost his job because Trung was simply not a good worker. If Trung's employer sacked Trung because the injury caused by Reggie meant that Trung could no longer properly perform his work, then Reggie will have caused Trung's loss, that is, the loss of Trung's job. On the other hand, if Trung's employer sacked Trung because, quite apart from the injury that Reggie caused Trung was not a good worker, then Reggie will not have caused Trung's loss, that is, the loss of Trung's job. Trung will have lost his job not because of what Reggie had done in injuring Trung, but from a cause that was unrelated to Reggie, that is, because Trung was not a good worker. Let's take the concept of causation a bit further. In some cases, it might be that it is not what the defendant does or omits to do that causes the plaintiff's loss, but that the plaintiff's loss is caused by something unrelated to what the defendant does or omits to do. We call this an intervening event. In this case, the defendant would not be liable to the plaintiff for a civil wrong because it was the intervening event, rather than the defendant, that causes the plaintiff's loss. For example, suppose that Meeson, the defendant, injures Thomas, the plaintiff, in a fight, and that Thomas is taken to hospital to be treated for his injuries. At the hospital, a doctor injects Thomas with antibiotics, but Thomas is allergic to those antibiotics and he has an allergic reaction which causes him brain damage. The question is, did Meeson cause Thomas's brain damage? The answer to this question depends on whether Thomas suffered brain damage because Meeson injured him, so that Thomas was sent to the hospital where he was injected with antibiotics that triggered an allergic reaction, or whether Thomas suffered brain damage because of an intervening event, that is, the doctor injecting Thomas with antibiotics to which Thomas was allergic. If Meeson caused Thomas's brain damage, then Meeson will be liable for that loss. On the other hand, if the doctor injecting Thomas with antibiotics was the real cause of Thomas's brain damage, then Meeson will not be liable for that loss because he did not cause Thomas's brain damage. As you might have guessed from our discussion on causation, another important concept in civil law is the concept of loss. Loss means a type of damage or harm that is suffered by a person. Look down the left-hand side of your vocabulary sheets, find the term loss and write this definition in there. There are a number of different types of losses that a plaintiff may suffer. I've listed some of these on the left-hand side of this slide. Losses may be economic or financial losses, property damage, personal injury, pain and suffering, or loss of amenity, which is also referred to as loss of enjoyment of life. Let's see what each of these types of losses is in the context of an example. Patience is a skilled dressmaker who enjoys running marathons. Felicity drives negligently and crashes into Patience's car. Patience is taken to hospital with a severely broken hand and leg. The question is, what losses has Patience suffered? Well, the first type of losses that Patience may have suffered is economic or financial losses. As a result of Felicity's negligent driving, Patience has been taken to hospital with a severely broken hand and leg. Because Patience can't make dresses while she's in hospital, she will have lost income. That is, the money that she would have earned if, instead of being stuck in a hospital bed, she was making dresses in her shop. In addition, if Patience can no longer make dresses because of her very badly broken hand, then she will have suffered a loss of earning capacity. That is, because Patience's hand has been permanently damaged, she will not be able to make dresses in the future when she's released from hospital. And so she will no longer be able to earn money as a dressmaker. She may well be able to earn money from another job, but it's likely that this other job will be lower paid because her special skill is as a dressmaker. And Patience will have had to pay the hospital for medical expenses in treating her. This is another kind of economic or financial loss that Patience has suffered because she's had to spend money in paying her hospital bills. The second type of loss that Patience has suffered is property damage. Patience's car has been so badly damaged that it's a write-off, so Patience can no longer drive it. It's now worth nothing. The third kind of loss that Patience has suffered is personal injury. Patience's bones have been broken. The fourth type of loss that Patience has suffered is pain and suffering. This refers to the ongoing pain and suffering that Patience has because of the crash. In this case, it may be that Patience suffers from ongoing pains in her hand and that she also suffers from depression because she can no longer work as a dressmaker. And the fifth type of loss that Patience has suffered is loss of amenity, also referred to as loss of enjoyment of life. Patience used to enjoy running marathons. However, if the car crash means that she can no longer compete in marathons, perhaps because her broken leg is not healed properly, then Patience will have been deprived of the opportunity to do something that she really likes. You need to be able to explain the concept of loss and the different types of losses with examples. The final key concept that you need to understand is the concept of limitation of actions. This requires you to consider whether the plaintiff's claim is outside the limitation period for that claim. Parliament has passed laws which specify the time within which a plaintiff may initiate a civil claim against a defendant. In Victoria, this law is called the Limitation of Actions Act 1958. If a plaintiff brings a claim against a defendant after the applicable time limit has expired, then the defendant can raise a defence that the claim is out of time or time barred, and the court can prevent the plaintiff from proceeding with their claim. You're now in a position to describe the concept of limitation of actions. Limitation of actions refers to the fact that there are laws that specify the time within which a plaintiff may initiate a civil claim against a defendant, and that, if a plaintiff brings a claim against the defendant after this time limit has expired, the defendant can raise a defence that the claim is out of time or time barred.
Look down the left-hand side of your vocabulary sheets, find the term limitation of actions and write that description of limitation of actions in there.
Different time limits apply for different types of civil action. For example, where a plaintiff sues a defendant for breach of contract, then the plaintiff must bring their action, that is, sue the defendant, within 6 years of the breach of contract. Where a plaintiff sues a defendant for negligence, then the plaintiff must bring their action, that is, sue the defendant, within 6 years of the plaintiff suffering loss as a result of the defendant's negligence. Where a plaintiff sues a defendant for defamation, then the plaintiff must bring their action, that is, sue the defendant, within 1 year of the publication of the defamatory statement. On the other hand, where the defendant has committed physical or sexual abuse against the plaintiff as a child, and the plaintiff sues the defendant for that abuse, there is no time limit within which the plaintiff must bring their action, that is, sue the defendant. There are a number of reasons for limiting the time within which a plaintiff must initiate a civil claim against a defendant. First, this provides certainty for the defendant. The defendant will not have a potential claim by the plaintiff hanging over their head for years and years. Second, the longer the plaintiff takes to bring their claim, the less reliable is the evidence likely to be, at least where that evidence is the evidence of witnesses. After a long period of time, witnesses may forget important evidence, not be able to be located, or may have died. Finally, social cohesion requires that disputes are resolved as quickly as possible. Outstanding claims disrupt society and may cause stress to both the plaintiff and the defendant. Well, that brings us to the end of this video. As a result of watching and taking notes on this video, you should now be able to explain key concepts of civil law, including the concepts of plaintiff, defendant, the burden of proof, the standard of proof, breach, causation, loss, and limitation of actions. Don't forget to read the pages from the textbook referred to on the first slide. And if you find any additional information from that reading that you think is useful, then supplement your Cornell notes with that additional information. Thank you for your attention.